jury's view of him. The danger of this unfair prejudice outweighs the probative value of explaining the officer's procedures. Now, if the defendant made an issue of the appropriateness of the officer's actions, the balance could shift, and the story of the slain officer could become relevant.
Now, Officer Best, when the defendant gave you his driver's license, you took down the information from it, you put it on the citation, you compared the photo on the license to the driver, and you explained the citation to him. Isn't that correct?
Objection! The prosecutor is leading the witness.
Sustained.
During direct examination, the questioning party shouldn't lead or suggest the answer to the witness. This can be difficult to identify, but questions that are actually thinly disguised testimony by the questioner shouldn't be allowed. Rule 611C controls leading questions. Questions ending in rhetorical flourishes like, "Isn't that correct?" or prefaces like, "Isn't it true that?" are easily identified as leading questions. Leading questions are perfectly okay on cross-examination or when questioning adverse witnesses on direct examination. However, leading question objections should be sustained during direct examination of presumptively cooperative witnesses.
What was Mr. Law's date of birth?
I don't remember right now, but if I could see the citation, it could refresh my memory.
May I approach the witness, Your Honor?
You may.
His date of birth is May 25th, 1968.
So he is over 17 years of age.
Objection! She's leading, and a witness can't review stuff when he's testifying.
Ms. Prosecutor, do you have a response?
Just developing testimony, Your Honor. Refreshing memory is proper under Rule 612.
Objection overruled.
Leading questions can be allowed for technical issues that develop testimony on topics like age, jurisdiction, and employment. Leading questions concerning issues in contention or dispute, however, should not be allowed. As to refreshing recollections, witnesses can review writings before or during their testimony. Once a document is used to refresh a witness's memory, the side using the document must allow inspection by the opposing party.
Ms. Prosecutor, has Mr. Law been provided a copy of the ticket?
Yes, Your Honor. And I am showing him what I just handed the witness. Officer Best, how does the radar work?
Well, the unit is calibrated by the use of a...
Objection! The officer is not a scientist and not an expert in radar.
Sustained. Ms. Prosecutor, you have not qualified the witness as an expert.
Officer Best, have you received any training in the use of radar?
Yes, ma'am. I was initially trained at the DPS Academy. There we spent over 20 hours in the science behind radar. In addition, I've attended 3 continuing education programs in radar. There was one in Indianapolis, Indiana, where we spent 32 hours in the science behind the radar, its construction, use, and maintenance.
So you can tell me how it works?
Absolutely.
Objection! The officer is still not a scientist, and you can't be an expert unless you're a scientist.
Overruled.
This brings up one of the more difficult areas of the law of evidence, expert testimony. Witnesses must testify to what they saw, heard, know, etc. Opinions are usually out of bounds. The exceptions are experts. Experts are persons with scientific, technological, or other specialized knowledge. They must be qualified by knowledge, skill, experience, training, or education. The expertise must match the testimony. Establishing the witness's expertise and the qualified knowledge, skills, training, or education is called predicate. The predicate must be established before the witness can testify as an expert. That is why the judge sustained the earlier objection. The judge overruled the second objection because the officer's training qualifies him to give expert testimony, even without academic degrees or qualifications. The expert must simply have some knowledge not possessed by the average individual.
How do you make sure the radar is working?
Well, you test it with a special tuning fork. I do this at the beginning and the end of every shift.
And how long has this been your habit?
6 years.
Did you perform the test on the day you wrote Mr. Law the speeding citation?
I don't recall, but...
Objection! He can't say if he can't recall.
Response, Ms. Prosecutor?
The testimony concerns personal habit. It is admissible as such under Rule 406.
Objection overruled. Officer?
I'm pretty sure I did test it. I do it every shift.
The prosecutor was correct. Rule 406 allows testimony as to a person's habit or an organization's routine practice. The habit or routine practice is relevant to whether the act took place, regardless of the general rule of personal knowledge.
So, Officer Best, why do you think Mr. Law decided to break the speed limit?
He didn't say, but my guess is that...
Objection! The officer can't guess or speculate on that.
Sustained.
Witnesses can only testify to what they did or observed. Expert witness testimony is the exception discussed earlier. Regular witnesses are usually only competent to testify to those things for which they possess personal knowledge. Speculation, guessing, and similar assumptions are objectionable and inadmissible. Welcome back. We left off with the witness being passed from the prosecution to the defense.
Okay, Officer Best, you get bonuses for making your quota of speeding tickets, don't you?
That is not true. There are no bonuses and there are no quotas.
In fact, there is a bonus system and there is a mass conspiracy.
No, sir.
Of course. You're a part of it. Liar, cheat, admit it. You are under oath. Admit the conspiracy.
Objection. Badgering the witness.
Sustained.
As we discussed earlier, the court must keep control of the parties. The court is specifically charged with protecting the witness from harassment and undue embarrassment. Difficult but relevant questions should be allowed. However, witnesses should not be subject to the bad overacting one sees in some courtroom movies. Repeatedly asking the same question, ridicule, and undue sarcasm are not appropriate.
Continue, Mr. Law.
So what is your daily quota?
There are no citation quotas.
What is your weekly quota?
Asked and answered, Your Honor.
Sustained.
Give the parties some leeway, but don't allow needless repetition of questions when there's been an objection.
Officer Best, doesn't your salary paid out of the police department budget come from honest taxpayers like myself?
I don't know the source of the police department budget.
I asked the court to take judicial notice that the city police department is funded by the city, which in turn raises its funds through taxation.
Any objections by the state?
No.
The jury is instructed that the police department is funded by the city, who in turn raises money through taxation. You may accept this as proof or reject it.
Be very careful when you're asked to take judicial notice. It should only be taken of matters that are indisputable. If it can be found in an almanac or official record, if it is something everyone knows, then judicial notice may be taken. The judge should inform the jury that a fact is proven, should they choose to accept it, by the court taking notice. The rules also specifically require the court to hear both sides before taking notice.
Officer Best, when you approached my car, my wife told you I wasn't speeding, right?
Objection. Hearsay.
Sustained.
Now we have entered another area in the rules of evidence that can be difficult. Hearsay. First, a hearsay statement is one that is offered into evidence to prove the truth of the matter asserted. Next, matter asserted means matters explicitly asserted or implied if the probative value of the statement offered comes from the declarant's belief of the statement. If an individual commits an act by speaking words, the probative value of the statement is that it was made, not that the declarant believed it was true. As an example, a person in a crowded room shouting "fire" is not hearsay if the evidence admitted shows he endangered the public. The statement is hearsay if it was introduced to prove that there was, in fact, a fire. Allowing hearsay would allow a witness's statement